Hello and welcome back. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on estate planning, legacy, taxes, property, and everything else in my clients' minds. This is an episode about changes in tax law that are scheduled to take effect on December 31, 2025. Right now, as I'm speaking, it's September 2024. And the questions are already pouring in. What to do in the face of these potential changes? There was a recent article in the Wall Street Journal that does a really nice job of summarizing these potential changes and maybe what to do about it. The title of that journal is in the show notes. But that article is also great because it reports on this. It provides specific examples of comments from practitioners and situations and strategies clients are using. And I'm actually scheduled to give a talk on this subject to various industry groups several times in the next few months. And those talks are longer, but this episode will be brief. So this issue is on everyone's mind, these changes that might take effect at the end of 2025. So it's a great time for this brief episode. You know from my previous episodes that current estate tax law is based on the estate tax exemption. This is the total amount that a person can pass to others free of gift tax during life and free of estate tax upon death. Right now in 2024, that exemption is $10 million indexed for inflation. So as of right now, that exemption is $13.61 million per person. And that exemption is reduced by taxable gifts made during a person's life. Remember, too, that spouses can double up that exemption through splitting gifts or through a process called portability. So for married couples, you can think of this as $20 million total indexed for inflation, or right now in 2024, that'd be $27.22 million. But the current tax law has a sunset provision built in, and this is what people are concerned about. At the end of 2025, if a new law isn't passed, then the exemption reverts back to $5 million indexed for inflation. So under current law, as it stands now, starting in 2026, let's call that exemption $7 million per person. Again, that would be adjusted for inflation to 2026. Now that's still a lot of money that an individual can pass to others free of gift tax and estate tax, but clients can't help but ask. They say, right now, I can give away $13.61 million during life or upon death. But if I wait until January 2026, and if a new law isn't passed, then I can only give away, let's call it $7 million. That's a difference of about $7 million that can pass tax-free. And at a 40% estate tax rate, that would be $2.8 million worth of tax that might be incurred in the future. But keep this in mind, not only do you have gift tax exemption, you also have an exemption from a separate tax called generation skipping transfer tax, or GST tax. I actually talk about GST tax a lot. I talk about that in episode 4. And GST tax exemption is actually a way to avoid estate tax at your children's deaths. That's hopefully a long way off. Remember episode 25, we talked about what is a dynasty trust? How can you use a trust to benefit multiple generations? But if you're interested in legacy planning in a tax efficient way, then you should also be concerned about the use of that GST tax exemption. And guess what? Right now, in 2024, you have a GST tax exemption of $10 million indexed for inflation. And at the end of 2025, that $10 million exemption is scheduled to be cut in half to $5 million indexed for inflation. So in any event, the logic is compelling. There are significant opportunities for future tax savings if you act now. And people are starting to feel that pressure, hence all these emails and calls that I'm getting, hence the Wall Street Journal article. They feel that pressure. Use it or lose it. But the challenge is, to use that exemption, you have to make a gift. You have to make an actual gift. And as you've seen from the other episodes, maybe one way to think about these gifts is that you have to give up certain things. You have to give up, we so often talk about 3 elements. You have to give up access to those funds, you have to give up control over those funds, and you have to give up flexibility over those funds. So let's take a step back as we approach the end of 2025. Here are just a few brief thoughts. First, let's remember the history of the estate tax. We've actually been here before several times over the past 15 years where the exemption was scheduled to go down at the end of a certain year. And in those years, lots of clients rushed to make decisions and to make large gifts. So let's learn from that history. I think there are two big takeaways. First, we did learn that people ended up rushing. Banks set up a record number of trust accounts in 2012, which is one year that the exemption was scheduled to go down. And attorneys and other advisors in this area were very, very busy during that time period. So let's learn from that. Don't rush. Be deliberate. Start thinking about this issue now. Don't wait till the end of 2025. And then if you do want to make a decision, hopefully it'll be based on careful thinking with your advisors over maybe a year and a half, maybe longer, and not this rush decision at the end of 2025. Second, keep in mind that each time when the exemption was scheduled to go down, the exemption actually has stayed the same or it's gone up. That actually includes a bill signed into law by President Obama. So a new law might actually be passed at the end of 2025. By the way, it's easy to say that it's hard to imagine Congress and the president all agreeing on certain tax law changes in this very politically charged environment. But it's happened before where Congress and the president have agreed on these changes in the tax law. So it's certainly possible that a new law could be passed at the end of 2025. So how about this? If the law changes, where do you want to be? So that no matter how the law changes, whether it stays the same and the sunset occurs, or whether the exemption is increased or stays the same, you've made the right decision, or you make a decision that you feel good about. So what do we do here? What are the options? And then we want to also think about what are some potential solutions. And I like to link those two, as you see from the episodes on this podcast. What are the potential problems or risks, and what are the solutions? We always want to make sure the solution fits the problem. The problem is current law and the expiring estate and GST tax exemption at the end of 2025. There might be lots of reasons you're considering a taxable gift, and we talk about those on this podcast. You might be thinking about transferring an asset with a relatively low value now that you hope will increase in value in the future, or making those what we call annual exclusion gifts of $18,000 per person. But if you're not concerned about that expiring exemption, then you probably don't need to worry about the 2025 sunset. That is, you could just focus on your overall concerns and overall strategies. But on this episode, we're talking about strategies that would help you address this potential expiration of the estate tax exemption at the end of 2025. So let's focus on those strategies. Let's think about how the exemption is used. You know, it's easier during my presentations when I have a flowchart or a whiteboard, but here in this podcast, I'm going to do my best. Think of this estate tax exemption like a meter. Let's say I make a gift of $1 million in 2024. That means that as of 2024, I've used $1 million worth of my gift tax exemption, and I can now give $12.61 million. And then let's say that the exemption goes down to $7 million in 2026. What I would want to do is I would want to essentially count from the top. I'd want to say in 2024, I had a whole lot of exemption and I used $1 million worth of exemption. But I'd say I gave away the extra, I gave away the top. So in 2026, when my exemption goes down, I'd say I still have that full $7 million exemption. But that's not the way the code works. The code actually counts from the bottom. It says, well, in 2026, how much exemption do you have now as a starting point? And I've said, I think we're going to start with $7 million or about in 2026. And then it would ask, how much exemption have you used through prior taxable gifts right now as of 2026? So actually, I would have $6 million worth of exemption left. Again, the code almost counts from the bottom, whereas I'm trying to count from the top and say, I only gave away that excess. So where does this lead us? Well, this means that if you want to use this extra estate tax exemption before the sunset, if you want to make a gift while it's at this, what I call the high watermark of the estate tax exemption, you actually have to make a really large gift. You have to make a gift that is so large that it is more than the exemption that you think you will have in 2026. So where does that lead us? Again, that leads us that if you want to try to avoid this expiration of the estate tax exemption in 2025, you really have to make a very large gift. So let's think about those strategies. Well, you could make a gift that's just outright. That is simple and that's efficient. Now keep in mind those gifts that are just outright typically don't use GST tax exemption. So those funds might trigger estate tax at the child's death. You could also make a really large gift to a trust. And we often think about these trusts as almost supercharged for gift and GST tax purposes. You could put these assets in a trust so the assets are protected from the creditors of that beneficiary. You can make this trust exempt from gift tax, estate tax, and GST tax. So there's no estate tax at a beneficiary's death. So now let's think about the disadvantages. And the disadvantages are actually common to all of the strategies that we talk about on this podcast. But in this case, the gift is very large. And there's also this element of time pressure that might pressure donors to make gifts they might otherwise not make. So these disadvantages are really key or also supercharged in this context. Right now, let's think about the status quo. You essentially have 100% access, control, and flexibility, for the most part, for your own assets. But if you make that gift, you're giving that up in some form. And you might change your mind, or you might need those funds and wish you hadn't made that gift. Or you might otherwise decide that it wasn't a good decision for any number of reasons, like changes in the beneficiary situation or changes in tax law, or you might decide to give more to charity. So in all these strategies, you give up that 100% access, control, and flexibility. Well, keep in mind, there are ways to maybe address that. We talk about a way to maybe preserve some indirect access through like a SLAT in episode 11. We talk about ways to maybe retain some indirect control, such as the ability to remove and replace trustees. That's episode 10. And we also talk about maybe how to give someone some measure of flexibility. We talk about powers of appointment in episode 22. So there are ways to maybe address some of these disadvantages and limits, but again, they're very real still. Another risk of these gifts is or relates to the step up in basis for income tax purposes. This is a little technical, but if you pass away owning assets that are included in your estate for estate tax purposes, then for the most part, those assets get a step up in basis for income tax purposes. Essentially, all the past capital gain is forgiven. And when the beneficiary after your death receives those assets, if they sell it, they pay almost no capital gains. They pay capital gains based on the fair market value of your date of death. So it's a way to wipe away all this prior capital gains. But if the assets are in one of these irrevocable trusts, they don't get that step up in basis for income tax purposes upon your death. So income tax planning ends up being an important element of this as we sketch out the real tax savings. There's a but here too. You can try to address the basis of these assets by exchanging assets with the trust, maybe making sure that over time you're moving assets back and forth so that the assets in the trust have a high basis and the assets in your name have a low basis. Again, that's a pretty technical comment, but it's a very real concern we want to pay attention to. So again, there are any number of other pitfalls and disadvantages we could go into. And these disadvantages are in place for most gifts, but in this case, they're just magnified. Okay, so here we are. We're almost at the end of this episode, and as you all know, that I like to leave you with some kind of thought exercise. So here's just a few parting thoughts. Number one, remember to focus on the problem. The problem is the potential expiration of the current estate and GST tax exemption at the end of 2025. So what are solutions that could address that problem? But this could also be a helpful exercise to have you focus on your overall plan. as we often talk about on this podcast, what are your overall goals for this property during life and upon death? And also, what if you need it? Or what if you make a gift and the funds aren't used the way you wanted? Or what if a new law is passed and the exemption stays high? Or what if the law changes, but in some other, maybe unexpected way? I'd want to make sure that no matter what strategy you choose, or whether you choose action or inaction, you're comfortable no matter what might come in the future. So here are some steps to take now. Clients are often wondering, what can they do now? And the first thing I would say is talk to your advisors. Start now if you haven't started already. Have that longer conversation so you're not rushing to do things at the end of 2025. Also, review your own estate plan. You might have already thought about how the assets should pass at your death, in trust or outright, who the trustee should be, all these other issues we talk about on this podcast. So maybe you've already started thinking about that structure, and so you can just start to translate that and think, what would that look like if I made gifts over the next year and a half or so? So think about that structure of access, control, and flexibility. But also looking ahead, we might want to actually start this planning now. And some clients call this a starter trust. I love that term. They might set up an irrevocable trust now and fund it with a relatively small amount of money. Now, that does force you to make the decisions now about the structure of the trust, but then the trust is set up. So then in 2025 or at the end of 2025, when everyone's really busy, you don't have to worry about setting up a new account or getting a tax ID or all these other things that might be much more difficult at the end of next year. So then that trust is in place, and then your only decision over the next year and a half is whether to put even more money into it, maybe make that large gift to the trust. You can also think about, at this point, moving assets into your spouse's name if you want your spouse to be able to make separate gifts. As we talk about on that prior episode about the step transaction, it's really important that any steps in these transactions be separated by time and other factors. And then remember that no matter what you decide to do or not do about the end of 2025, remember to apply those same lessons back to your overall gifting strategies during life and upon death. And, lastly, I'll repeat, did I mention talk to your advisors, be deliberate, start that conversation now if you haven't already. Well, thanks again. I'm Steve Murphy, and this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.